Good afternoon. Hi. It is my pleasure to introduce David Moran, clinical professor of law and co-founder of the Michigan Innocence Clinic at the U of M Law School. He and his colleague, Bridget McCormack, launched the clinic in 2009. Their goal, to investigate and litigate claims of innocence by convicted prisoners in cases where DNA evidence is not available. Thanks to the clinic's work, 45 innocent people have been released. All totaled, they had served more than 700 years behind bars. Professor Moran, who retired as clinic director in 2024, has argued before the Supreme Court, U.S. Supreme Court, 6 times. He holds undergraduate and graduate degrees in physics and mathematics and earned his JD from the U of M Law School. Professor Moran, we are honored to have you with us and look forward to learning how the clinic has successfully helped overturn multiple wrongful convictions and the problems in our criminal justice system that these so many cases illustrate. Thank you very much.
Thank you for that introduction. Can everyone hear me pretty well? Good. I am really low tech. I usually don't use PowerPoint, but I will today. But it won't be a lot of PowerPoint, at least there's that. As you heard in the introduction, I co-founded the Michigan Innocence Clinic in 2009 with Bridget McCormack, who at that time was the Associate Dean for Clinics at the University of Michigan Law School. I had been a professor at Wayne State Law School for 8 years prior to that time. So today I'm going to talk about why we founded the Michigan Innocence Clinic, how the Michigan Innocence Clinic worked, show you then some of the cases that we litigated and won and the lessons that we can learn from those cases about what went wrong that caused those people to be wrongfully convicted. And then I'll talk in detail about one of the 45 cases that the Michigan Innocence Clinic had won during my tenure, the case of Levon Hill. So that's my agenda, and then I intend to leave plenty of time for Q&A. So the reason that we started a clinic at Michigan was because we had seen over the previous 20 years that there was a problem with the criminal justice system that was exposed by DNA. So starting in 1989, DNA came online as a forensic tool to solve crimes. The problem is that the vast majority of felonies committed in America, there is no DNA to test. But as soon as we started using DNA in 1989, we started also retrospectively using DNA, not only to solve pending crimes, but to see if we had the right people in prison already. And so in 1990, we had our first DNA exoneration in the United States. It was a case from Illinois, a man named Gary Dotson. And we've had a steady stream of DNA exonerations ever since. We've had over 300 DNA exonerations in the United States since 1989. Many of them have been shepherded by an organization, a nonprofit in New York called the Innocence Project. Many of you have heard of the Innocence Project. Many people assumed that our clinic at Michigan was somehow part of the Innocence Project. They are separate organizations. The Innocence Project was set up in the early 1990s by Barry Scheck and Peter Neufeld to test cases where people had been already convicted to see if they were innocent by using DNA. So the Innocence Project in New York is a DNA Innocence Project. And after the Innocence Project was set up in the 1990s, various regional and state level Innocence Projects were set up around the country. And we got then this steady stream of people who were exonerated of crimes by the use of DNA. And we also started to see from these cases some lessons. We started to learn that the criminal justice system was less accurate than we had previously believed. There was a dominant paradigm until DNA came along that our criminal justice system is exceptionally accurate because we have in the United States, we have this Constitution. The Constitution guarantees you the right to counsel. It guarantees you the right to be convicted by a jury of your peers, the right to confront the witnesses against you, and so on and so forth. And so we collectively as a society believe that wrongful convictions were really rare, that they're kind of like being hit by lightning. It's really rare. It happens, but it's not something we really needed to worry about. Was the dominant paradigm. But as soon as these DNA exonerations started rolling out, starting in 1990, we learned that that really wasn't true, that our criminal justice system was less accurate than we thought. And so since the DNA exoneration started, various academics have tried to estimate what is the wrongful conviction rate? What is the probability that somebody who's been convicted of a felony in the United States is actually innocent? And various studies have used different databases. For example, one database looked at rape cases in Virginia because Virginia saved rape kits for decades after people were convicted. So it's possible to go back and test rape kits where people have been convicted without the use of DNA technology to see if the right person was really in prison. There was a study of rape murder convictions in southern states that was done. And there was a study that was done by my former colleague, Sam Gross, who used to be a professor at Michigan Law School, on death penalty cases, generally from around the country. And all of these studies came up with numbers in the low single digits, like around 4%, somewhere between 4 and 6% where all these studies landed. So that doesn't sound like a lot. You know, if you make 94 to 96% of your free throws, you're the best free throw shooter in the history of the NBA. 4 to 6% error rate doesn't seem so bad in that context. On the other hand, would you fly an airline that says our chances of crashing are only 4 to 6%? You wouldn't. And a wrongful conviction is maybe not as bad as an airplane crash, but it's certainly a lot worse than a missed free throw. And so that number seemed to be worth being concerned about because the costs of wrongful convictions are pretty high. So, of course, the most obvious cost of a wrongful conviction is an innocent person is languishing in prison. And then there are the costs to that person's friends and family, lost income, children who lack parental support. So there's those problems. But there's, of course, also another gaping problem that arises when you have wrongful conviction, which is the real perpetrator is still out there. And in fact, this is one of the major lessons to learn from wrongful convictions generally, is that once the police identify a suspect and turn the case over to the prosecutor's office, investigation usually stops. So even if other leads come in after the police have said, we've got our guy, the police are very likely to ignore evidence that contradicts the theory that they've already got. We call this tunnel vision. It's a cognitive bias. It's a human thing that once we think we've solved something, we have the answer, we tend to be not very receptive to being told that perhaps we're wrong. And of course, if we leave the real perpetrator out there, that person feels emboldened because they got away with it, and they're likely to commit more crimes. And I'll illustrate with just one example from here in Michigan that has nothing to do with my clinic. This was from before when my clinic existed. But there was a case in Lansing where there was a community college professor. Her name was Carolyn Cronenberg. She was in her classroom at Lansing Community College, preparing to teach her class. And then the students came into the classroom and they discovered the body of Professor Cronenberg. She had been strangled in her classroom. And the Lansing police immediately focused on a man named Claude McCollum, who was a homeless individual who often spent much of his days on the Lansing Community College campus. So he was brought in, he was interrogated. Mr. McCollum had mental illness issues, and in short order, the police obtained a statement from Mr. McCollum that didn't actually confess to killing Professor Cronenberg, but said if he had killed her, this is what it would have been like. This is what it would have seemed like. And that was it. That was all the evidence against Claude McCollum. It's all they needed. And Claude McCollum was convicted of the murder. About a year later, his appellate lawyer discovered that there was a video that the police had that showed that Mr. McCollum was asleep in a chair in the campus library during the period when Professor Cronenberg was in her classroom and when she was murdered. And this piece of evidence had not been turned over to the defense. And so Mr. McCollum was exonerated. But it turns out that there was plenty of evidence that could have pointed to another suspect, because that caused the police, Mr. McCollum's exoneration, caused the police to go back and look at the physical evidence recovered from Professor Cronenberg's body, and there was DNA, and that DNA hit on a man named Matthew Macon, who was subsequently then charged and convicted of Professor Cronenberg's murder. But in the interim, Mr. Macon is believed to have killed 3 more women in the Lansing area. So that's a really vivid illustration of the high costs of a wrongful conviction, especially when the investigation shuts down too early. The police don't dot every I and cross every T, and the real perpetrator then goes on to commit more crimes. The other lesson that we learned from the DNA exonerations is what causes wrongful convictions. I've already talked about one of the causes, which is tunnel vision. The police focus on an individual and the investigation shuts down. But there are other causes, and these are considered to be the leading causes of wrongful convictions. On the previous slide, I gave a book, 2 books here, for those who want to read more about the causes of wrongful convictions. Barry Scheck, Peter Neufeld, and Jim Dwyer, who's a reporter with the New York Times, wrote a book called Actual Innocence in 2003. This looked at the first 50 or so wrongful convictions that were remedied by the Innocence Clinic in New York, and examined these cases and looked to see what went wrong. Brandon Garrett is a professor at the University of Virginia Law School, wrote a book called Convicting the Innocent some years later that looked at the first 150 DNA exonerations in the United States, and again cataloged what went wrong in each of these cases that caused an innocent person to be convicted while the real perpetrator was free. And both of those books came up with the same list of 6 types of errors that lead to wrongful convictions. The first being eyewitness misidentifications, which is close to 80% of the DNA exonerations featured a witness who came into court and said, "That's the guy." And then DNA later proved that it wasn't true, that wasn't the guy. False confessions, I've already indicated one, the Claude McCollum case. Close to 20% of the DNA exonerations featured a confession from the defendant extracted by the police, oftentimes from people like Mr. McCollum, people who have mental illness, or young people, or people who are high or drunk when they're interrogated by the police are especially likely to falsely confess. But what we've learned from the DNA and non-DNA exonerations is that actually all of us are vulnerable to a false confession. Under the right conditions, just about anybody will eventually, under pressure, admit to committing a crime that they did not commit. Police and prosecutorial misconduct, and primarily what we're talking about here is withholding evidence. As again, I indicated happened in the Claude McCollum case. The police had a video showing that Mr. McCollum was in the library at the time that Miss Cronenberg was killed, but they didn't turn it over. Now, the police officers involved said, well, we didn't turn it over, not because we were trying to frame this guy, but because we believe that the timestamp on the video had to be wrong. And why did the timestamp on the video have to be wrong? Because we got this statement from Mr. McCollum. So you see the circular reasoning, but well, he had to have done it. Therefore, this evidence showing he didn't do it has to be wrong. So that's a leading type of prosecutorial or police misconduct is when the police or prosecution have evidence that points away from the suspect and they don't turn it over. And again, usually it's not because they're trying to frame him. It's just because they believe this evidence has to be a mistake. It's junk. It's trash. We don't need to turn it over because it's not real evidence. Ineffective assistance of counsel is shown to be a leading cause of wrongful convictions, and I believe it is the leading cause of wrongful convictions in Michigan. Until relatively recently, Michigan had one of the nation's worst systems for providing lawyers for poor people who've been charged with crimes. The system, thankfully, has gotten better, starting under Governor Snyder and continuing under Governor Whitmer. We now have the Michigan Indigent Defense Commission, which has dramatically improved the quality of indigent defense in Michigan. But there are many, many people still in Michigan prisons who were convicted, who had basically no effective representation at all. A particular interest to me, as you heard, I have a background in science. I was a physics and math guy before I decided to go to law school, is erroneous forensic evidence. And there's lots of things here. Bite marks, for example, have been virtually completely discredited as a reliable source, a reliable source of forensic evidence. Hair comparison analysis, which is where the analyst takes a hair from the crime scene and a hair from the defendant and looks at them side by side under a microscope. You often see that on shows like NCIS or CSI. That is a complete junk science that I do not believe it now is used anywhere, but is been used to put away scores of people. The way that arsons were investigated in the United States until the early 1990s has turned out to be a complete junk science. Fire investigators were trained that if they saw certain indicators in the house, such as something called alligatoring, where the wood beams look like the back of an alligator's back, the scales on an alligator, so-called pour patterns, if they see these irregular splotches on the floor of the house that's been burnt, that was supposed to indicate that an accelerant was poured. All of these things have now been scientifically tested beginning in 1992 with the National Fire Protective Association doing extensive studies on these supposed indicators of arson, and it turns out that none of them are actual indicators of arson. And so there have been scores of people exonerated nationwide who are convicted based on those indicators. And then the use of incentivized testimony. So this is where somebody has a particular reason to give testimony against the defendant in order to help their own case. Maybe they're a co-defendant with the defendant, or maybe they have a completely separate case and they'll claim that they heard the defendant in jail admit that they committed the crime, and they didn't actually hear any such thing. They make up a confession by the defendant, and nearly 25% of the DNA exonerations have featured incentivized testimony that turned out to be false. And as you can see, there's other things as well, like general racism, judges who commit misconduct are other causes, but those 6 over and over again have been shown to be the leading cause of wrongful convictions. Now, if you think about it, there's no reason that these same 6 reasons for wrongful convictions wouldn't be true in a case in which there's no DNA to test. And in fact, the vast majority of cases, there is no DNA to test. So CSI and NCIS and those other shows make us think that there's DNA everywhere. There's DNA. You can always test the DNA. But in the vast majority of felony convictions in the United States, there is no DNA to test. There is DNA to test in the great majority of one type of felony, and that's sexual assault, for obvious reasons. There's usually DNA to test there. But the great majority of murders in the United States, there's no DNA to test. There are some murders where you might find DNA, strangulation or close combat with a knife, you might find DNA. But in the United States, we usually commit homicides by shooting people. And when you shoot somebody, you don't leave DNA behind. So the great majority of homicides, there's no DNA to test. So let me give a little bit about my background now. I graduated from Michigan Law School in 91. I clerked for a federal appeals court judge for a year. And then I spent the next 8 years at the State Appellate Defender Office in Detroit. And there I was assigned about 200 felony appeals. So these were people across Michigan who've been convicted of all kinds of different felonies. And most of them, there was no claim of innocence. Most of them were plainly guilty, but there were issues with how the trial was conducted, or there were issues with the sentence they got. But of those 200 cases, 5 of them turned out to be cases of people who were completely innocent, had nothing to do with the crimes for which they were convicted. We were able to prove it because we had an investigative unit at the State Appellate Defender Office. We were able to find the evidence we needed to exonerate these people. And we did exonerate these people. And that taught me that there was a serious wrongful conviction problem. And none of those cases had DNA. We were able to exonerate them without finding DNA. And so this taught me that while the DNA exonerations were great, we needed to have a way to reach people who were innocent, who'd been falsely convicted, and who did not have DNA to test. And so I got together with Bridget McCormack, who had been a public defender herself in New York before she got into academia. And the two of us got together and we decided we would start the nation's first exclusively non-DNA innocence project as an innocence clinic at U of M Law School. I say non-DNA almost entirely because it's not that we're against DNA, but there is a DNA Innocence Project in Michigan. It's based at Cooley Law School, and it was founded in 2001. So we would, if there was DNA, we would pass it on to the Cooley Innocence Project rather than keep the case itself. We did, in one case, do DNA testing that resulted in an exoneration because Cooley had passed on that particular case. So it's not like there's anything wrong with DNA and we wouldn't do it, but we would just, in the vast majority of cases, we would pass the case on to the Cooley Project. People often ask, how are you funded? We are funded by the law school like all the other clinics. There are many different clinical programs that allow law students to work on real people's cases. There's, I think, 16 clinics that are currently going on at the law school right now, and we're funded by the law school like all those other clinics. We would have about 20 law students work in the clinic per year, plus we had to cover summers because the cases didn't stop during the summers. So altogether, we have about 26 students per year. The students who work during the fall term have to come back for the winter term. So we required a 2-semester commitment, and it was 7 credits each semester. So the idea is that we expected them to spend about half of their time for a full academic year working on these cases because these are big cases and it required a lot of commitment to do it. How did we pick the cases is a question that people always ask. How did you actually decide which cases to take? Well, once we decided to open the clinic in fall of 2008, Bridget and I went to the news media and announced we're going to open this first of its kind non-DNA clinic. And we hired an administrative assistant to be our administrator for the clinic. And we told her, once we do this, you're going to get a lot of mail. Are you ready? She was, because we got 2,000 letters within 2 weeks of when we went public. There were at the time about 50,000 people in prison in Michigan, and we've heard from about 7,000 of them. So not everybody who's in prison claims to be innocent. That's a myth. Most people who are in prison got there by pleading guilty, in fact. But we heard from a lot of people. And what we would do is we would then mail them a questionnaire to fill out, asking lots of questions about the crime, they're convicted, what appeals they've had already, who their lawyers have been, and so forth. And once those questionnaires come in, we would assign them to 2 students. We would tell the 2 students, you can't talk to each other about this case until you've finished your review. When they finish their review, which consists not only of reading the questionnaire, but going online, reading any judicial opinions they could find online about the case, reading any news media they could find online about the case. And then they each write memos. We had 3 attorneys in the clinic, Bridget and I, and then we quickly hired Imran Syed, who had been a student in the clinic and graduated, and he became our 3rd member of the team. One of the 3 of us would read the 2 memos written by the students, and we'd make an initial determination, do we want to look into this case? Not we're taking it, but do we want to look into this case deeper? And only about 1 in 10 of the questionnaires that were sent to us resulted in what we call a further investigation. And then once we decided to further investigate, we would assign the case to 2 students, usually not the same 2 students who did the initial questionnaire read, and that we would tell them, go, find out about this case. So they would go get the transcripts of the trial and read it. They would talk to the prior lawyer. They would talk to some of the witnesses. They may go to the crime scene. They would file FOIAs to get documents from the police or the medical examiner or whoever else might have important documents related to the case. And they would work it up. And this workup often took months, sometimes years. Case may be a further investigation for us. Some cases, even 5 years, we would investigate the case. And ultimately, we get to a decision point, and the question we would ask is, are we as a team firmly convinced this person is completely innocent of the crime for which they were convicted? And if so, do we have evidence that we think will convince the judge of it? And if the answer to both of those questions is yes, we took the case. And again, it was about 10%. So we got 7,000 questionnaires that turned into about 700 further investigations, which turned into about 70 cases that we accepted for litigation. And once we accept a case, then what are we going to do? We're going to go back to court. And you go back to court in the county where they were convicted in the first place. In fact, in front of the same judge before whom they were convicted in the first place, if that judge is still available. And of those 70 cases that we took, we've won to date 45 of them. And the ones that we haven't won, we don't close. We keep them open because, again, we only took the case because we were all firmly convinced the person was completely innocent. And so you don't want to say, well, sorry, we lost. Good luck to you. We will keep trying. And one thing we'll do to keep trying the cases we lost is we'll go to the governor and try. And we had 3 victories where the governor has granted clemency even though we lost in court. But we were able to convince the governor's staff that though there were barriers that prevented us from winning in court, this person is in fact innocent, and the governor should release them. So here's the list of 45. The longest serving, number 18, is Richard Phillips, who served 46 years before we exonerated him. He was a 25-year-old married auto worker, father of 2 kids. When he was convicted of a murder in 1971, when he was framed by the guy who actually committed the murder, who became the star witness for the prosecution. He came out in late 2017, and he's a brilliant artist. You can look him up, Richard Phillips, exonerated Michigan artist, and see examples of his artwork. His work has been featured on CNN, CBS Evening News, and he's become a close personal friend of mine. In fact, he's doing extremely well. The shortest anyone served is Salisa Lakini, number 7 on our list. She served 41 days in the Oakland County Jail for failure to pay child support. The reason she couldn't pay child support was because she was involuntarily committed to a mental institution. So anyway, those are the people that we've successfully represented. And one thing that we can learn from these cases is how are the DNA cases different from the non-DNA cases. And 45 is maybe not enough, to do a real study, but anecdotally at least, there are some pretty clear differences between the DNA and the non-DNA exonerations. So the DNA exonerations, as I already indicated, are overwhelmingly in sexual assault cases. The non-DNA exonerations are all over the place. They're everything from Salisa Lakini's failure to pay child support, to robberies, arsons, child abuse, because we've exonerated a number of people who are convicted on the shaken baby syndrome theory, which has become very controversial in recent years. But more than half of our exonerations are in homicides, murders, where there was no DNA to test. They are far less likely to feature an eyewitness misidentification than a DNA exoneration is. And that makes sense because most of the DNA exonerations, as indicated, are sexual assaults. And so most of those are cases where the victim of the sexual assault came in and identified the defendant as the person who had sexually assaulted him or her. And so it's not surprising then that the DNA cases are very heavily likely to be eyewitness misidentifications. Only about 20% of the non-DNA cases featured an eyewitness misidentification. False confessions about the same in both sets. More likely to feature a bad forensic science. More likely to feature police and prosecutorial misconduct, and more likely to feature incentivized testimony, all because the non-DNA exonerations are heavily homicide cases. And it's in the homicide cases where the police feel especially pressured to solve the case. Those are the cases that we especially expect the police to solve. And so they're more likely to result to a bogus forensic science. They're more likely to engage in misconduct like not turning over exculpatory evidence to the defense. And they're more likely to rely on a jailhouse informant. For example, a burglary case, they're very unlikely to rely on a jailhouse informant. Only major cases like homicides do they tend to do so. And they're far more likely to involve ineffective assistance of counsel, which kind of makes sense because we were able to find the evidence that exonerated the defendant, which indicates that the defense lawyer at the time of trial probably missed something. If we were able to find it years later, probably the defense lawyer at trial should have found it at the time. So it's not surprising that the great majority of our cases featured ineffective assistance of counsel. So I'm going to close by talking about one case in a little detail. The very tall man in the middle is Levon Hill. Levon's number 44 on that list. There, he served 23 years for a murder he didn't commit. The woman in, here we go. The woman there is Jenna Cobb. She's the person who replaced me when I retired from the Innocence Clinic in 2024. So let me tell you about Levon Hill's case, and then I'll stop and take Q&A. Levon Hill's case arose from a double murder that occurred in Detroit on September 8th, 2011, just 3 days before the 9/11 attacks. The police got a call, that's a Saturday night, Sunday morning, they got a call at 3 a.m. Sunday morning that there have been shots fired on Keating Street. So the police go to Keating Street and they find 2 bodies in the street and nobody else. Whoever was there has gone. Whoever called in is gone. They just find 2 bodies and nothing else. The 2 men were identified as Ronnie Kraft and Deshaun Lucci. The police go and talk to associates of Mr. Kraft and Mr. Lucci, and nobody knows anything. People are not very cooperative. Those who are cooperative say that they don't know anything. There's a detective now who's assigned to the case, and his name is Walter Bates. And 2 days later, Walter Bates picks up a man from the neighborhood named Andre Meredith. Andre Meredith is a guy who's been in and out of prison for various things. He suffers from mental illness, and he's illiterate. The Sergeant Bates picks up Mr. Meredith, takes him to Detroit Police headquarters, and detains him, locks him up illegally because he has no reason to suspect him of anything, and demands that Mr. Meredith tell him who killed Mr. Lucci and Mr. Kraft. Eventually, what emerges out of this is a signed statement written out by Detective Bates that claims to be from Andre Meredith, where Andre Meredith says that he saw a man he knows named Levon commit the double homicide. He says that he saw Levon Hill walk up, pull out a handgun, and kill these 2 men. So Mr. Hill's arrested, and they go to a preliminary hearing. And at the preliminary hearing, Mr. Meredith very, very reluctantly testifies to this sequence of events. And then right after the hearing, he tries to go talk to the judge, and he ends up leaving a voicemail on the judge's phone saying, "Everything I say is not true. The detective forced me to say that stuff. It's not true." But that's enough for Mr. Hill to be bound over for trial. And so the case goes to trial a few months later. And again, the prosecution calls Andre Meredith. And this time, Mr. Meredith gets on the stand and says, "It's not true. I couldn't even read this statement. Sergeant Bates wrote it out. I didn't say any of this stuff. Sergeant Bates made it up." And other than the signed statement, there is literally zero evidence. I mean, none. There's no motive. There's no connection established between Mr. Hill and these 2 men who were killed. It's just this statement that is being retracted by the person who made the statement. And that is all the evidence that was needed to convict Levon Hill of 2 counts of first-degree murder and send him to prison for life without parole in 2002. So this case comes to us, and this is obviously very problematic. The students quickly contacted Andre Meredith. It comes to us 20 years later. We contacted Andre Meredith, and Andre Meredith stands by that this was not a true statement, that he wasn't there, he didn't know anything about the murder. But that's already been established. The jury already heard that. So that's not enough. We can't just say the jury got it wrong. We have to come up with new evidence. That's what the clinic's work involves. We have to find new evidence that will overturn the conviction. And over the course of several years of investigating this case, we came up with 4 pieces of new evidence. The first piece of new evidence was we thought it was curious from the autopsy results of the 2 men that the medical examiner didn't find the bullets inside their bodies. The bullets had actually passed through the bodies of both men. That was a possible indication to us that a high-powered firearm had been used. And so we FOIA'd the evidence reports from the scene, and it turns out the evidence technician had recovered 4 shell casings from the scene. So we sent that information to a ballistics expert, and the ballistics expert said those shell casings came from a high-powered assault rifle, such as an AK-47. Well, remember, the statement that Mr. Meredith signed said that he had seen Levon Hill pull a pistol. But we have a ballistics expert saying it wasn't a pistol. It was a high-powered assault rifle. So that's pretty good, we think. The second line of evidence was that while Mr. Hill was sitting in prison in the Upper Peninsula, various people from the neighborhood cycled through. When you're in prison for a long time, you may see people you know from your neighborhood come through, and various people told him that they knew more about the circumstances under which Mr. Lucci and Mr. Kraft were killed. And we contacted 2 of these people, a man named Sherman Wagner and a man named Cordell Powell, both of whom told our students who interviewed them that they were at the scene that night. In fact, what they told us was that there was a dice game being held on the front porch of an abandoned house on Keating Street, and that Sherman Wagner, one of the people who talked with us, had won $700 from a man named DeAndre Murray, and Mr. Wagner then taunted Mr. Murray. Mr. Murray went away for a little bit, and then he came back with, you guessed it, an assault rifle, and opened fire and killing Kraft and Lucci. Mr. Powell told us basically the same story, that he had seen Sherman Wagner taunt DeAndre Murray, and DeAndre Murray came back with an assault rifle and opened fire. The next thing we heard was that member of Mr. Lucci's family didn't believe that Levon Hill had anything to do with this case. Levon Hill was an acquaintance of Deshaun Lucci and was on friendly terms with him. It would have no reason to shoot Mr. Lucci or Mr. Kraft for that matter. And so we went and spoke with members of Deshaun Lucci's family, and Deshaun Lucci's ex-girlfriend told us that her son had information for us. So we found the son, his name was Deshaun Lucci Jr., and the students spoke with him, and Deshaun Lucci Jr. told us that he was 8 years old when his father was killed, but that about 8 years later, when he was 16 or 17, DeAndre Murray came to him and apologized for killing his father. So that's really good, right? Where the son of one of the murder victims is telling us that somebody else apologized to him for killing his dad. And he has no reason to lie for Levon Hill, doesn't know Levon Hill, and didn't know that Levon Hill was in prison. He didn't know anybody had been convicted for his father's death until we told him. And he said, absolutely, I'm willing to come and testify about what DeAndre Murray did. We also looked up DeAndre Murray. It turned out he was dead. He was killed in a shooting in, I think, 2012. So that's 3 really good pieces of evidence. The ballistics evidence, the witnesses who were at the dice game, and Deshaun Lucci Jr. The 4th piece of evidence, because so many of these cases involve police officers who, to put it mildly, were shady, when we have a case like this, we look up the police officer. We want to see if there's other cases involving the same police officer that involve similar misconduct. And what we learned just about caused us to fall out of our chair when we looked up Walter Bates. So what was Walter Bates up to in the fall of 2002 when he was the star witness against Levon Hill in trial? We learned that while Mr. Hill's trial was going on, Mr. Bates, Sergeant Bates, would leave the court and go with his brother and a third man and rob banks. You can't make this stuff up. Levon Hill was convicted in September 2002. Between August and October 2002, Sergeant Bates, his brother, and the third guy robbed 14 banks in the Detroit area. Now, do you think it might have had a bearing on how the jury viewed Sergeant Bates's credibility had they known that he was robbing banks during the trial? Yes, we did. And so we put all of this together, and this became a case where we did not have to actually file the 6500 motion, the motion for relief from judgment. We presented it to the Wayne County Prosecutor's Office, and they have a conviction integrity unit that Kim Worthy established in 2018. And the conviction integrity unit looked at all this evidence. They talked to Deshaun Lucci Jr., they talked to Sherman Wagner and Cordell Powell, and they finally agreed in the fall of 2024 that Levon Hill's conviction had to be overturned. They dropped the charges, and he was released. And Levon Hill is doing very well. He was married in 2011 in a prison ceremony to his longtime girlfriend. They had known each other since grade school. She's a hospice nurse and was there for him when he was released in November 2024, about a week before this photo was taken. All right, I'll stop there. And that's kind of a high note, right? Just and I'll be happy to field questions.
Oh, got one right. Oh, Carol got ahead. All right.
So if the police pick you up for something and take you to wherever they take you, and they can lie to you, right?
Yes.
Okay. And if you immediately say nothing but I want an attorney, is it their attitude that you're guilty?
Oh, yeah. Yeah.
But is that what you should do?
Yes, absolutely.
Okay. Thank you.
Yeah.
I've always said that when I watch.
Yes. No, you say, I want my lawyer. I want my lawyer. I want my lawyer. I want my lawyer.
So on the previous screen, we listed all the 45 successful cases. That Richard Phillips shows up again at 33.
You are very observant.
And it says, again, what was going on there?
So he was framed for 2 different crimes by the same guy. The guy who testified against him in the murder, which was in Wayne County, also testified against him in an armed robbery that he committed in Oakland County. And so Richard Phillips looked like Fred Mitchell. Fred Mitchell was the guy who committed both the armed robbery and the murder. They resembled each other. And so Richard Phillips became Fred Mitchell's get out of jail free.
Hi, thank you. Very interesting. 2 hopefully short questions. One, you said that there's 70 cases that you've accepted. Is that over the whole time of the project, and are you still reviewing them?
Well, I'm out now. I retired.
Yeah.
But yes, cases are still being reviewed. But yes, the 70 cases comes from the very first case, which we accepted in January 2009, which is the same month that the clinic opened. till now.
And then do you often, as in the example that you gave, find the actual culprit?
Yes. Unfortunately, it's often hard to exonerate somebody unless you do, right? Because even though you've got strong evidence the defendant didn't do it, to convince the judge or the prosecutor, as in the case of Lawan Hill, oftentimes you have to give them an alternative narrative and a specific person. And so quite a number of our cases, the evidence that we found not only strongly indicated our client didn't do it, but pointed to an alternative suspect. And in only one of those cases did the prosecution ultimately go after the person we identified, and they convicted him. And that was the only DNA case. I mentioned there was one DNA case we ended up doing, which is Jamie Peterson, number 9 there on the list, from Kalkaska County, way up north. That was a DNA case. We managed to get the DNA tested, and not only did it exclude Jamie Peterson, but it hit upon a guy who actually had been in the pool of original suspects and been dismissed by the police. And so the prosecution then, after dropping charges against Jamie Peterson, prosecuted that guy and convicted him. And he's serving life without parole now instead of Jamie Peterson.
Thank you for your insightful talk. I'm curious, are there any consequences for the police or the prosecution when the misconduct is divulged through your research?
Usually no, other than bad publicity. Usually nothing. There was a case, Desmond Ricks. Where is he? 15. Very good, 15. Yeah, Desmond Ricks, where the police fabricated a match between bullets pulled from the victim's body and Desmond Ricks's mother's .38. She had a gun in her nightstand that the prosecution and police claimed at Desmond's trial was used in the murder, and they claimed a match. The police claimed a match between the bullets that the medical examiner pulled out of the victim's body and bullets that would be fired by Desmond's mother's gun, and that was a fabrication. They switched bullets, and we were able to prove it. And I called the Attorney General after we won the case, the Attorney General's office, and said, "You got to go after those 2 officers." And they said, "Statute of limitations. Too late." Now, the good news is Desmond sued, and he collected, I think, $14 million. But is that enough for 25 years? Would you give up the best 25 years of your life, young to middle age, for $14 million? I don't think any of us would. But no criminal consequences.
Question here. Actually, just a comment. A book called The Innocent Man by John Grissom about a man wrongfully convicted in Oklahoma. It's a really good book to read. I just read it recently, and it's what this guy went through in his life, and he was in prison. I forgot for how many, 20, I don't know, long time.
Death row.
It's real, yeah, and he was on death row, and what he did there. It's a very interesting book if anybody wants to follow up more on this.
I'm actually from that part of Oklahoma. I grew up in that judicial district. I know many of the characters in that book. It's an excellent book. By the way, I'm writing a book now. I'm co-authoring a book about this topic, about lessons learned from the non-DNA exonerations. Hopefully it'll be out next year.
Okay, if I can. I'm thinking what an incredible experience this is for the students. Do you have any idea of how this experience influenced their career choices later on in law?
Yeah, well, many of our alums, we have now well over 200 alums from the Michigan Innocence Clinic. Many of them have ended up as public defenders, and many of them are now working in innocence projects. There is a national organization called the Innocence Network, which is kind of like a trade association for innocence projects, around the world. And we post to an alumni listserv job opportunities and from the member organizations. And many of our students are working in Innocence projects now.
Great talk. I love this. I have a couple of things I was wondering about. One, the percentage of people represented seems to be largely Black or minority. And
Yes.
two, what happens when they get exonerated? Are they immediately released, or do they have to spend time waiting to be released after they've been exonerated?
I'll take the second question first. When they're exonerated, they walk. So to be exonerated, I didn't define the term. To be exonerated is the conviction is overturned and the charges are dropped, or the defendant is acquitted at a retrial. Only one of our 45 was retried. And that was Julie Balmer, number 4. She was retried and acquitted. All the others, the conviction was overturned, and then usually maybe a week or some weeks later, the prosecution then drops the charges, and at that point, they become exonerated. The convictions can be overturned, and they may sit in jail, like they're awaiting retrial. But then once the prosecution drops the charges, then they're released.
Why would they not be allowed to be out on bail?
Well, we make a motion. We always make a motion, but most of these cases are murders. And most people who are charged with murder don't get out on bail. And so most of our clients, the conviction's overturned. They're theoretically awaiting retrial, even though we know that there won't be a retrial because we found new evidence that would make it impossible for them to win a conviction. And they may sit in jail for weeks or months before we get them out. But the first question about race. Race is definitely a factor. So obviously, we all know Black people are overrepresented in the criminal justice system. They're overrepresented in prisons. They're even more overrepresented in lists like this. And so that suggests that that racial factors make people of color more likely to be wrongfully convicted than others. And study after study has shown that.
Last question.
Hi, thank you so much. This has been really, really interesting. It strikes me that these are like dramas that could be on TV. You know, the students get involved along with their faculty mentors in doing some really on the ground detective work. It's not just lawyering, and that I think of looking up cases and case law and so on. Is it dangerous?
No. Okay. But yes. So we worked hard. I should use past tense since I'm retired from the clinic now. We worked hard to make sure that we weren't putting our students in undue danger. And we had volunteer private investigators who would work with us. And so if a situation was dicey, we would have one of them. By the way, these are people you've heard of. Bill Proctor and Scott Lewis are both investigative journalists, Detroit TV stations, both became retired and became private eyes, and they both volunteered their time with us. So if there was a situation where we thought there was danger, we would have the students go with them. We still wanted the students to get the experience. But if the situation we thought was dangerous, like, for example, we're going to a house where we think the real perpetrator might live, we would have the students go with one of them. But for the most part, we had the students not go, private investigators, because we wanted the students to get the experience. We wanted the students to take the lead in doing the investigation. And I'll tell you that only once has a gun been pointed at any of our students, which is one time too many. But of all things, that was a police chaplain pointed a gun at one of our students. We thought that was safe. We thought that it wasn't. But our students remained calm and actually got the information they were there to get. So, all right. Well,
Thank you very much.
thank you.